We can
Okay,
start.
here we go. We're live now.
Okay. Good evening, everyone. Welcome to the February 4th, 2021 meeting. Is there a motion to formally open the meeting?
I make that motion.
Second?
I second.
All in favor of opening the meeting, please signify.
Aye. Aye.
Aye.
Meeting is officially open. Is there a motion to review and approve the minutes of the meeting of January 21, 2021?
I make a motion to approve,
Second.
review and approve.
Did I hear a second?
I second.
Any discussion on the minutes for the meeting of January 21?
Yeah, I do. I had a question. Did Ms. Goldstein have the opportunity?
Got to speak up,
I'm
Brian. I can't hear you.
I'm sorry. I said, did Ms. Goldstein have a chance to review the minutes per your email?
I did not send the minutes to Ms. Goldstein, as she is not a member of the committee. Did we have a discussion about sending her the minutes for her comments, or did I make that suggestion? Forgive me.
I think that we talked, you sent an email out about sending it out to the people who participate. And I did not want to reply because I think this is probably better discussion that we have here while we're officially as a committee and the public is overhearing. But my feeling would be that the public comments are best reflected in copies of the Zoom audio. And that I think that should be their comments as they came to us. That is the best. And if they would like to clarify or send something else in, I mean, that's their prerogative. But I think that the committee minutes should be, as the committee said, this is an overview of the Zoom comments. And if a member of the public would like to clarify something they said, we should afford them the opportunity to come back.
Oh, that's a good point. Mark I just got an email from Mark saying, would someone please send the dial-in? He would have been sent the Zoom link. I requested that be done. I trust it was.
Right, and Sally said she was going to do it.
I'm going to just reply and tell him.
Yeah, there's an opportunity to just dial in on that Zoom link.
Make sure he got it.
Robert just sent him the link.
Oh. All right. So hopefully he's on shortly. Let me load up the minutes. I'm sorry, let me do the share screen on the let me do Mark's share screen. Let me do Mark's. Where's my cursor? Come on. Oh boy. Try it again. I think I have to save Mark's. There is his. Okay, let me try that again. Share screen. That's not working. Let me try it again. I'm going to try to load it up. Save. More time.
Oh, wait a minute. Hold on. I think he's in.
Yep.
You're in?
Thanks, folks.
Okay.
I don't know what. I know.
I,
I'm vexed or jinxed or whatever.
You've done a lot of Zoom. This doesn't make sense,
I
right?
know, all day long, my whole life. Good evening.
having
everyone.
trouble getting Mark's edit loaded up. Share screen. All right, where are you?
The
Miles?
truth be told, I had spent a bunch of time writing kind of a presentation and then turned to your comments a couple hours ago and saw you covered a lot that I was otherwise going to speak towards.
Well, for some reason, I am having trouble loading up Mark's edit.
Where are you stuck, Dan?
I hit share screen, and when I usually hit share screen, I see my Word documents.
It's a PDF. That might be it.
So maybe it is in, yeah, maybe that's the problem. Well, I have it as a Word document. And I'm doing share screen.
Oh, my comments. Yes, my comments are, I also sent along a PDF of the prior report I had sent you all.
Yeah, but I'm looking for your actual edited, and if I hit share screen, I am not getting my I'm not getting my Word documents. Let's see.
I'm going to resend it, Dan, just in case. Did everybody else get it?
Yep.
Okay, cool.
Well,
Actually,
I don't know how to explain it other than that. Well, while you're resending, let me just respond. Mike, I agree with you 100%. You are correct in so far as the videoed recording of our meeting is the best record of comments that were made. The minutes do not, I would say the minutes do not take precedence over the actual videoed meeting, which is what it is. All right, I got your, let me try to see if I can access that again now that you've sent it to me. Let's try it one more time. Now I'm getting a screen. Oh, wait a minute. Wait a minute. Yep. Ah, got it. Wonderful.
yep, there we go.
Ah, I didn't have to call my son in Philadelphia. That's great. Okay, so moving on. Brian, I think we've answered. Any more comments regarding the sending the minutes for comment or not sending the minutes for comment?
No, I agree with Mike.
Okay, so that aside, are there any other questions, comments regarding the minutes of January 21? If not, is there a motion to approve the minutes?
I make a motion to approve.
Second?
I second.
All in favor signify by discussion on the motion. In the absence of discussion, all in favor signify by saying aye or show of hands.
Aye.
Aye. Minutes are approved. Brian, thank you as always. Moving on to the second item on the agenda, the status of mailing or emailing the letter our committee letter informing the community and others of the existence of the committee and soliciting comment. That letter finally went out. Thank you, Nora, for your diligent, persistent, and hard work on that. It went to the Village of Mamaroneck employees. And as you know, we did get a request from the head of the Mamaroneck PBA, Charles Deshensky, requesting an opportunity to comment. I think you saw my reply, which was very appreciative of his reaching out and offering him the opportunity to, and any member of the police department, to contribute to the work that we were doing, and told him he can come to a meeting. And I think I also said in the email that we'll accommodate we'll accommodate his schedule, meaning that we'll talk to him by phone. I'd be certainly willing to meet him via Zoom at a special meeting. I think we're all very eager to get comments from the community. So he replied, I think you saw his reply, was that he had necessarily had comments to make, but he has the code we're working on, and I think now we'll just await any contribution he or any other member of the police department wishes to make.
I'm not sure it went to every employee. I think it went to the heads of the unions first.
That's it?
I think that's what happened, yeah. So I don't think it went to everybody. I think it went to just the heads of the unions.
Can I comment on that for a sec,
Yeah.
Jen? I think it should go to everybody at this point, and I'd like to make sure that our letter goes, and if there's informal communication that we can have with the union heads, because I felt that the email that went out with the exact phrase, answer questions, lead this more to be, an inquisition, which it is not. This is more gathering information and fact finding. And our intent here is to gather information from the lowest level, the village employees, that they feel could be beneficial to this process. And so I felt that email may have turned people off. I'm not looking anybody answer questions, and they can send their comments in. They don't have to answer anything. And I think at this point, we should just move forward to a little informal communication. And I would recommend by the chairperson of this committee to reach out to the heads of the other unions and say, we just want anything, we want you to have input, whatever it may be.
Well, I am still obsessed with getting this word out. Everyone who works for the village of Mamaroneck. And a couple of thoughts. Nora, can we get the email addresses for the union heads who were contacted? Because if we can get that, I would communicate with them myself and say, and in the manner in which you've just expressed, Mike, making it very clear, we seek their contributions. This is not an inquisition. We just want them to know we exist, and we are interested in their thoughts.
I mean, I'm sure you could email them directly. They're village employees, so they would have a village email address. It's usually the first initial of your first name, your last name, and it's at. And I guess the police department has a different, I have to look. It's.
All right. Well, I'm going to ask you as liaison to help us on that. At step one, I will email them, but step two is we need a direct instruction from the Board of Trustees or the mayor or someone to say we need a blast email to everyone who works for the village of Mamaroneck with this message.
Yeah, I mean, that's really from the manager, but I think we have a meeting on Monday. I'm not sure why it went just to the heads of the unions. There might be a reason that I don't understand. But I thought it was going to go to everybody and it hasn't. So I think, I can't explain why. Maybe someone else has a better idea. But
do you think there's a concern that the manager is sending it out to all the employees? Do you think there's a concern there for some reason?
I don't know. I mean, I don't know why it's just gone to the 3 union heads, not to all the employees. I don't.
But
Was it the letter? Was it the letter that we passed along, or was it rewritten?
I'm not sure. Let me see if I can find it.
While you look, Dan, you sent it directly to you sent it directly to him, or did we send it through Nora?
What? Did I send
Request.
So I don't know. I'm just trying to think. Jerry sent it to union presidents on Friday.
Right, but we also have non-union employees.
Yes, we do. I can't explain why it hasn't gone to employees. And
we were specific with Jerry what we wanted, right?
Yeah.
Okay.
And could I ask one question? Nora, is it possible for the board, either in a work session or at the regular session, just to, vote on this and make this, official thing in the furtherance of the committee's work important that
yeah, I mean, honestly,
all employees just instruct the manager.
I think that's, I don't know why Jerry feels he has to do it with the unions first. So that's probably the first question to ask, or the union heads first. But I'm just not sure why this hasn't happened. We have a meeting Monday. It's not scheduled for the agenda, but maybe we can add it. I will try to.
All right. I would suggest to Nora that you tell them that we are incandescent with rage.
That's not a phrase I would think of, usually associate with you, but okay, I will.
Yes, I am incandescent with rage,
Okay.
which is an expression, I don't know where I got it, but I love it. But kidding aside, this is bloody February, and we've been in business for over 3 months, and we are trying to communicate with the very people who are most subject to this code, and we can't get to them. How was that incandescent? So
You're not glowing, but okay.
we live in a democracy. So all right, I think Nora, please, whatever you can do to importune them, be it by vote of the board. At the very least, if you could get the emails for me, I'll email them. I think we've made the record. Okay. Anything more on that before we move on? By the way, I didn't put it on the agenda, but I think you all received from me after I researched the issue on recusal as it relates to a committee, and I sent you all what I found regarding that issue. And I think at the appropriate time we can, when we start getting through the sections again, which may not be for a couple of meetings, we'll discuss that in more detail. For now, I would like to introduce Mark Ettinger, who is the former chair of the Village of Mamaroneck Ethics Board, and who also does an extraordinary job at the Emerald Theater. I have to mention that because the Emerald is a jewel in our crown. But Mark, are here, your request, and we welcome you. We're glad to have you. And at this point, I invite you to walk us through your suggestions, recommendations for the code.
Terrific. Thanks, Dan. Thanks for the kind words about the theater. For those of you that I don't know, and I don't think I really know anyone particularly well. I may have met some of you. I've lived here in the village for 28 years. I raised 2 daughters in the public school system. I've served as president of a number of local nonprofits. I happened to go to law school, and then I got a master's of law after that. And I pretty much spent my career in different forms: law, business, banking, and the real estate banking business. I served on the board of ethics for, I didn't look back, I think it was 5 years, and roughly 3 as chair. I will make this point, and it'll be the only point because it's been suggested to me, and I don't want to go through cases or the Goldstein matter unless there's an applicability of the facts to a policy or legislative suggestion. But I do want to say, because it struck me, and this may, if this is upsetting anyone, I'm sorry. And I know Ms. Goldstein's on the phone, but when I heard at the end that, and there's no code suggestion here, so I'm asking your indulgence for 30 seconds. I don't think of ethics as an E word. When I heard E word, I think of the F word, the S word, the B word, all the things I used to tell my kids not to say something because it was bad. To me, when I heard E is ethics, that was disturbing because I assume you, like me, believe ethics is central, absolutely central to, I look at, there's numbers of people on this phone who have done public service, and ethics is at the core of public trust in government. So that is my last comment on that type of specifics. So I don't know whether, what I could do, Dan, because I didn't really integrate the comments I put in the margins of your guys' good draft, but I have a few adds that I might just do if that's okay. And I don't know whether sections that you did not appear to be amending were subject to further change. If they were, I would have comment. When we get to them, if not, I won't comment. But some specifics that I would suggest be incorporated, and a couple of these actually are. As you all know, the code in the investigatory language in section, I'll find it in a second, in the it requires the cooperation of all village officials and staff. And that was not always the case. In fact, sometimes quite the opposite, depending on the matter. And there is a clause that requires that cooperation. And I guess if somebody didn't cooperate, one could imagine that would be a violation of the code, but it's in 2113A, I think. But I think it would be good to add a clause that prohibits any person.
Hold on, let me go down to that, Mark. 21.
It's 13.
Hang on a second.
It says all agencies of the village and all public officers, board members, blah, 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 shall furnish to the Board of Ethics such data, information, and statements as may be, in the opinion of the board, be necessary or appropriate for the proper exercise of its functions, powers, and duties, which is good. That's a good thing. The issue on that is one issue on that is enforcement. It is a little problematical to ask a village elected or appointed official for information, and if they do not want to, you're left essentially with a choice of a violation or a subpoena. I would suggest that that could be supplemented, which would be helpful because it actually runs to what the issue is, that any person who's subject to the ethics code, meaning everybody that the ethics board has jurisdiction with respect to, should be prohibited from taking acts or encouraging others to impede or impair an investigation or other duly authorized activity. We have had that happen, and I just think that's a good ad, and it's a good message that one should not be. It's one thing to support your friends and allies, which of course the system allows and should allow, but when it crosses from that into actually trying to sidetrack or impede, I think that's different. My second, should I stop in between these, or I should just rip through them?
If anybody in the committee has any comment or question, they are free to jump in.
Okay, so
why don't you go ahead?
Okay, thanks. In section, and you guys addressed this in part, section 21.6 of the code requires that the BOT update the list of persons responsible to file an annual disclosure, requires to be done annually. The fact is we have asked.
Mark, just let me get to that section so we have that in front of us. You were saying 21.6?
I believe so.
Can I make a suggestion? Start at the beginning of the document and let's just go through all of Mark's edits in order instead of potentially going back and forth.
I'm happy to do that. I have 4.
Ellen, that's radical. That's radical.
I'm happy
sorry, I can't help it.
I don't know. I hope it's okay, Ellen, if I call you Ellen, but I just have 4 that sort of stand out as not dealt with. And if I could just mention those 4 quickly.
Sure.
I'm afraid I'll lose it given I have.
All right, did you want to go 21.6 now? Let's go to 21.6 since you brought it up, and try not to get dizzy as I paginate here.
I think you made.
That went too far.
Well, I'm almost there. I am.
There it is.
Bottom of the page.
That's it. You just went, there it is. So here this is actual practice. We have requested, and I'm not blaming anyone because there's a solution to it, and it's unreasonable to think that the board could do this on their own. I saw you made some suggestions. The suggestion that we had made originally when the board I was on sent our suggestions was that the village manager should be required to make recommendations each year to the BOT. But as I thought about it and what the scope of different jobs are, we looked at this about 3 years ago, where we lined up the folks who are subject to the code with those who were in the various positions. And we actually had people voluntarily filing who weren't part of it. But I think it takes more than the village manager, which I think was our suggestion, to figure out who should be subject to the code. And I would suggest the village manager and the village clerk, because at least the clerk knows all the boards, the village manager knows all the employees, and then once it gets to the BOT, it ought to be covered. But I would suggest that the village manager, village clerk have that annual obligation, the BOT have an obligation to review it, and somewhere in that process, given the experience of the ethics board, I would suggest it's good policy once the village manager and village clerk come up with their updated list, that when it goes to the BOT, it could go to the ethics board for comment.
So you're suggesting that not all employees are subject to the code, but rather who is determined on an annual basis be subject to the code by the village clerk and the manager?
Well,
no, it's not subject to the code, Jocelyn. It's
the code in 21.6. I don't have it. I can pull it up.
Designation.
Basically says that I'm only making
for the disclosure.
If you look at 21.6, first flush language preceding Cap A, and it says within 90 days, the effective date of this chapter, and during the month of January each year, the Board of Trustees shall, right? And what I'm saying, it's unrealistic. I don't believe the BOT didn't update it because, which you'll see further.
Mark, I understand your point, but I mean, having served on the board when we passed this, there are positions, regardless of the names associated with the positions, that we expected to be covered. And
of course,
So my understanding is the breakdown is in the names that go in those positions never happens. The marrying up of member of the planning board with Bob Jones doesn't get married. That's the real issue. The issue is, you know, the issue to me is there should be a schedule of all positions that are required to be
exists now.
That exists, and then the names that fit those positions.
Oh, you're saying, John, to start with the positions, and then I think the real problem, here's what I think the real problem is practically, I'll leave it to you, hopefully you'll solve it, is there's the original list from whenever 2009 when you enacted it. That list, I don't believe, it may have been updated once in the distance past, but I know for longer than the 5 years I've been on it, we've been asking the BOT to update it. I think it's hard for them to do that. So all I'm suggesting is on the annual basis versus just leaving it in the lap of the BOT, that the village manager and village clerk should supply any updates to the existing list, whether that be name or position, for presentation of the BOT. And I suggested a copy go to the Board of Ethics when that's done. That's my only suggestion.
Yeah, I mean, my concern there is, my feeling is the obligation should be on the person who is on a board or an employee or a consultant to follow this law. And I think you get away from that if the escape clause is the position was not, you know, that my name wasn't included in the list that the village is trying, you know, wants included. I think it works better if you do, you say all these positions, if that happens to fit your role, then you're responsible for filing. Because I think what we have so many, my area that I'm concerned with is the number of consultants and
John, I wasn't trying to exclude anyone. I just know.
No, I understand. But I mean, my concern is the oversight happens if somebody is a consultant, the name isn't included in the list of consultants that the village manager and the village clerk, you know, suggest, and they don't file, you know, we're sort of in limbo.
Right, but John, who would know better about all the consultants? The village manager?
I think any consultant should have to disclose at their hiring and annually. And that
which is fine, but I don't think, to Mark's point, I don't think the Board of Trustees, and Nora, I'm not trying to be offensive.
Or was I? There's a requirement in the statute to up. I'm only addressing, you guys do it.
No, I completely agree with you. I mean,
it's not updated. Okay. There are staff members who voluntarily do it because they know they should. I would not make this exclusive or say you have a safe harbor because your name's not on the list. Yeah. All this says is somebody in village government, the BOT, village manager, village clerk need to get together and actually do this in some fashion because it does not happen.
And I think
I agree, Mark.
The three parties together.
Okay. That's all I got on that.
Yep.
Mark, would this be equivalent of just establishing on an annual basis the minimum number of people based on their position who are required to file, and then having somebody within village government certify that, yes, they have all filed? And that's not all inclusive, but it establishes the baseline.
Well, that's what that actually, the second part, I don't know who's speaking because I don't know the person. Mike, I think that is. Hi.
Mike, yep.
Hey, nice to meet you. There is a provision in this code, that's what I'm addressing, that requires the BOD to update the list, right? For the village, somebody. All I'm making a narrower point is it needs to be updated. And then I think you'll find in operation of the code, other than the annual disclosure piece, this is just the annual disclosure. So a consultant in and out may or may not be. That doesn't relieve them of the disclosure requirements in 21.5C, 21.4N, applicant, or anything else. They still got to follow the rules. This is just so that what happens is on in January, Sally and now Yorm, who's the chair, will get together. They'll send these all out. We attach a little short, unfortunately inadequate, but short explanation of the code provisions. And then ensues the process I know you're trying to address in terms of deadlines for filing, suspension, et cetera. All I'm making is the narrow point. The list has not been accurate for years. That's it. I don't have a bigger, there may be bigger issues, but I don't, that was all, that was the limit of my comment.
Mark,
But also,
it's Mike again. You say that it's inadequate. What specifically is inadequate and what would you recommend to make it adequate?
I'm sorry, which element of inadequate?
You said that the notation, for lack of a better word, on this document is inadequate as to why they have to do it, right? Just a second ago you said that. What is inadequate and what would make it more adequate?
I may have either misspoke or misunderstanding, but what would make it adequate would be an appropriate list. And then what happens, Mike, is it goes out and they're told what day to send it. We then have an automatic reminder letter. I think we went to the BOT on this and set this up. 2018 was a disaster. We had half the board not send it in and maybe half the land use people not do it. So we went back to the board. Now we have a process where at 30 days you get warning letter, a reminder letter, then a warning letter. And then the only thing we can do could have done on the code was a violation. I see that you're trying to cure that, as my comments were as well. So what's, I don't know if I'm answering your question, or I'm just.
I think Mike was asking about the list itself. I think Mark was talking about the list itself, an effective list. And I think what Mark is saying is the list has to be reviewed
every year.
Reviewed every year, but certainly the list, according to what Mark is saying, is the list needs to be updated from the last time it was reviewed.
I think that's important.
Which I think was 2009.
Yeah, I think maybe part of our discussion should be an annual certification of the minimum number of people who are required to file and submit. We've already talked about sanctions or ramifications for those who don't file, but I think taking what Mark says, what is the list? Who are these individuals?
Mike, I don't know if this will help you. What we do, this has been the way the process worked for years. I inherited this. I didn't make it up. Is these disclosures come in, right? There's a master list by Sally. That's the list that has to get updated by the BOT, village manager, village clerk, at least in my suggestion. We send them out. We get them in, we sit around, and each person, I probably reviewed 400 of these, goes around, signs off on them, or says they forgot this, or they check this, usually 99% is clerical stuff. And then after now about 60 days, I don't know if this runs to your question, Mike, we send a report. This is by practice, not by law. I just adopted this because the compliance issues were so great in 2018, we needed to do something. So we started sending a report about 60, 70 days into the process, which was too late. That's what I think I meant by inadequate, of what officials have not filed yet. I think last year, we got it down to 8 who just didn't file. And we're essentially, if you're saying the Board of Ethics should certify and provide the list of everybody who has filed, that's easy to do because Sally keeps a running list of that with, coded check marks for status. I feel like I'm not addressing what you're asking, but I'm trying to.
So Mark, it's Ellen. I have a question. We have in this section that the Board of Trustees should be notifying everyone who has to do a disclosure. Is that correct, or should it be the clerk treasurer?
Where are you seeing that? I'm reading 21.6.
Right.
Language 3A, it says that during the month of January, the BOT shall cause to be filed with the ethics,
right,
the list. Right. That's what I'm addressing.
Okay, but look at point B.
And then B,
So
The way that notification has worked historically is by the mailing by Sally of the forms to each person with a letter that says, but it comes from the village clerk's office, not the ethics board, the village clerk's office, that says you're obligated to file.
So we need to correct that also, because the opening blurb says the Board of Trustees shall notify.
Yeah, but I think it's pretty understood. You guys decide, but it's pretty understood that the Board of Trustees acts through the clerk or the village attorney or someone.
Yeah, the village only receives documents through the clerk. So, I mean, that's.
Right, but I just think to clarify further, or maybe it's in my RACI matrix, we have that as the clerk treasurer.
Okay. Well, I can tell you this from experience, and you can ask Yorm or Jeff or any of the people who have done this, Mary Boza before that, you know, tons of people, is the reason for non-compliance isn't that they don't know, because they get the letter, they get a follow-up letter. It's not because they can't get a notary, and that notary is not for relative to proving your signature. It's meant for an attestation of truth. None of those are the reasons why we don't get performance. We don't get performance on a timely basis. One, because there's no penalty, if you will, which I know you guys are addressing, but just because whether it's the inadequate environment or inadequate training or whatever, that there's not a sense that ethics is paramount in the village. Because there's no doubt in my mind, having done this nonstop for 5 years, that we almost never, I mean, I can remember last year, I think there was 2 board members who had AKA names or different kind of emails that didn't get it, but we've never had that be any type of administrative challenge whatsoever. So I'd suggest the key thing here is getting the list right. That to me is the missing piece.
Mark, can I just ask
not a huge
question
problem,
unrelated to all of that?
Sure.
I note that you had changed the word shall, or recommended changing shall. Is that related to the word, or is that note related to just the comment about that whole area?
Yeah, it was related to, I just don't think it's fair. I'm not blaming, fair that BOT could do this. So that's what I meant by not sufficient.
Okay.
And that the burden should be on the manager and the clerk to provide recommendations to the BOT, BOE.
No, I was getting to the actual use of the word shall. I wasn't sure if you were
No.
Because we have, in the village, we have had that discussion. Is it shall, is it must, is it may? And
It's not may. It's either must or shall. It's must or shall, and law school was the same thing.
No, I understand, and we got tripped up on that one time in the past.
Yeah, I gotcha.
Okay.
That was all my point. So that's all I had on that.
It's shall in the original, and I think we agreed. I think I took a look at that, and I think that shall appears in the model code, if I recall correctly.
Yeah, my comment was it's not sufficient to expect the Board of Trustees to actually do it, because it's impossible. How could they? They're so busy. Okay, the next sort of point that I wasn't sure was covered, but we'll get to it in a minute. I want to talk, one of the recommendations I think need to be added to this is where there's a recommendation and that goes to call it the party with power of removal or sanction authority, some higher power.
Section, Mark? Are you addressing a specific section?
Now, yeah, I can. If you go to, the section on, excuse me?
You can focus us on a section, then we have a context.
Sure. It's the penalty section. It's 2114. But let me just make the point without drafting is, I know you're trying to address certain elements of this, and I made comments on this there, but there ought to be some onus on the party. If it's not a penalty that is deployable, whatever the right word is, by the ethics board, and it has to go to, say, the BOT, or if there's ever some other body, or the mayor, whatever the body is or person is, that body should, as a matter of public trust, confidence, act in relatively short order. Otherwise, it's a bit meaningless. And I would say that somebody who has been convicted, found guilty, whatever the right words are, continuing to act on a specific matter, which is my second point, second and third point, doesn't make any sense. And I don't want to go through exact cases unless you ask me to, but I would say, I know, I'm working hard at it, Dan. But I would say the sanctioning authority, if it goes there, and most matters never go there, should have to act, say, within 60 days. I would also suggest that if the recommendation were removal, then the subject who is found in violation with respect to whom a removal recommendation has been made should be suspended from service pending that decision by the sanctioning authority. Because it makes no sense to have a party go through, have in the public trust, go through an investigation, hearing, all of that, and then have the person continue to serve. I think it should also be clear, there should be an added remedy here, because this has come up before where you're in a bind. You don't quite think removal is the right sanction, but a civil fine or debarment or any of the other litany of penalties just doesn't make any sense. I would suggest giving the BOE the express power of suspension from the matter that was the subject of the violation, because it just can't make any sense otherwise.
Mark, you would recommend that the Board of Ethics should be, for lack of a better term, the fact finders, and then have power to take action and take that power away from the Board of Trustees?
No, well, that's not, no, I wouldn't. There is, if you look at the code and continue down in section B and beyond, you'll see that the Ethics Board does have power, powers of penalty that are, let's call it, generally less severe than removal. And I think it's very appropriate that only the appointing authority, whoever that be, have that power. That's too heavy a power to give the Board of Ethics, in my view, because listen, service is a privilege, but at some point, reputations and other factors are on the line. So I think that the penalties here that are already given to the Ethics Board discretion are fine. It's just silly at times. Like you're not gonna fine somebody. It's not gonna do anything just to fine somebody $500 and go ahead and say, go ahead, participate. That doesn't make any sense, if it's particularly on a recusal issue. So I'm saying or suggesting that one additional remedy be added to the powers of the Ethics Board, in addition to civil fine, et cetera, which is suspension from the matter on which the party was convicted. That seems to be narrow, it's not punitive, and it's directly applicable to the matter because they've been found, if they've been found in violation on a particular matter, it doesn't make any sense to have that person continue in the matter. It makes no sense to fine them $500 and say, keep going. So I would leave removal with the Board of Trustees for sure. No, we shouldn't have, no board should have that kind of power. No appointed board. But I think suspension is appropriate. And I think if you have, the board would have to, Ethics Board then would have to make a choice. If you found someone guilty, you would either just suspend them from that matter, or if you sought and believed the right remedy was removal, you would then pass that on to the BOT. But during the pendency of any action by the BOT to remove, it should to be automatic that if it's a recommendation of removal, the person should be suspended from service, not just the matter. That's the distinction I'm trying to draw.
Sorry, when you say
That dovetails with the 60 days so that the penalty wouldn't be longer than, say, 60 days.
Brian,
sorry, with the suspension from the matter, what if the matter is already decided? Like on land use boards, I know some applications are done that night. So what if like the harm's been done already and the application's already approved? How would the Code of Ethics take that into account?
Well, then you couldn't suspend, you obviously couldn't, I agree with that. That wouldn't apply, that factually wouldn't apply, and the Board of Ethics then would be left with one of these other remedies or recommend some other remedy to the authority that is not on the specific list of penalties that the BOE is allowed to impose. But if it's happened, you can't go, you know, someone else is smart, that's smarter, can figure out what you do. You know, that's up to the applicant to go back and sue or try to overturn if some harm was done. But this is, we're talking about the Board of Ethics, and narrowly I'm suggesting add suspension as an allowable, suspension from the matter be an allowable penalty to be imposed by the BOE, Board of Ethics, along with civil fines, et cetera. And if removal is but that's a big thing to recommend. That's a very heavy thing to decide to do. But if that recommendation is made, dovetailing with the 60-day requirement there be a hearing, so there's due process, I believe if that recommendation is made for removal, that party who's been found guilty should in that case be suspended from service on that board pending the decision of the appointing authority. I don't know if that was clearer.
Okay. Any other?
I just, you know, I wonder about the use of this though to the other extreme, where, you know, you have somebody, you know, somebody who's removed, going to Brian's point, somebody who's removed from a land use board pending a determination by the Board of Trustees. And my opinion is the removal decision should be, there should be one process and one process only. And I think it should be the Board of Trustees, because ultimately they're legally responsible for the village. So I think the Board of Trustees should be the responsible authority. But if somebody is removed from a land use decision process, and the process goes through in the time that they've been removed, and the Board of Trustees finds that there was not an issue, that they don't want to remove the person, there's no remedy for that.
I think that runs, John, I agree with what you start with, whether, I don't want to debate the BOT versus the mayor, that's too political. I don't want to get into that.
No, but I just think the Board of Trustees is ultimately the ultimate responsibility.
I agree. I didn't disagree with that. I'm just saying, first of all, think of this. Let's say you convicted somebody on a matter, and let's just say the matter was, let's pick something crazy, like a bribe, which has never happened as far as I know, a bribe of an official, something like that. And you do the investigation, you figure out they did it, you find them guilty because you go through due process and they've taken this bribe. I mean, it doesn't make a lot of sense to me that that party would sit on the board for a year or two.
No. I get it. I understand your point. I understand. I'm with you on that. All of that. My problem is an applicant comes before a land use board. There's an issue that arises. The ethics board finds that there has been a violation, and it rises to the level that that person needs, in their opinion, that person needs to be removed.
That's the case, right?
And it goes to the Board of Trustees, and the Board of Trustees determines, 60 days later that should not have happened for whatever reason, for whatever reason. And now the land use issue has been decided.
Well, I guess the question is, that could happen with someone sick or anything else. Did you have a quorum? Were you duly authorized as, I think that's why you have quorum rules. So if somebody is unable to attend, whatever the reason,
right.
It's also, we could get into a discussion of alternates, but that's a deeper hole. All right. I'm saying is it makes no sense for a person convicted on a specific matter.
No. And I understand your point. But I also think I would be in favor of shortening up to 60 days.
I agree. Totally.
To-
That's the right answer, because
to-
nobody is hurt and just long enough to have due process so that an applicant isn't sitting there and either being disadvantaged or adding to their allegations in their lawsuit challenging the finding of that board.
And hypothetically, if an applicant was disadvantaged, wouldn't they be made aware of their of the pendency of this issue?
Not necessarily, given the confidentiality rules. I mean, I assume they would notice that, that George Smith, who was there the first time, wasn't there the second night. But if there's a quorum, that's the standard for action is quorum. They still exist. And I think you're dead right. 100%. To disadvantage the fewest number of people. This gets to the level where the Board of Ethics, I frankly haven't been on a board where I knew anybody in the 5 years with 12, 15 members. I don't know. I didn't really know anybody I ever served with except in passing. So if you get to the point where you're actually finding someone guilty and you think it's important enough to remove them, that should be really important to the Board of Trustees that deal with without excuse forthwith. So as not to disadvantage the applicant and just enough and provide enough time for due process for the accused. Recognizing that this is a sanctioning hearing, if you will, not a trying of fact. So just like when it's a different hearing should be a different hearing when you're deciding penalty versus establishing all the facts, which is the case in American jurisprudence. Should I go to the next one?
Yep, let's do that.
Okay. But I think John and I were in the same place at the end. The shorter the period, the better. This is a pretty obvious one, but I don't think it's anywhere. And is that it ought to state somewhere that it's a violation of the code if you violate your oath of office or you give false testimony under oath before any board. It would seem to me you violate the oath or you violate an oath or a statement to a board. Obviously it's not a mistake. You're giving an intentionally false statement or a violation. That ought to be a violation, and it doesn't say that anywhere. Again, simply a violation of your oath of office should be a violation. I think that's pretty easy, I would think. We all take an oath of office. And then if you give false testimony, I think it's pretty easy to think of that as a violation. One could draw the distinction, I guess, between under oath or not under oath there, so that casual kind of testimony isn't brought in. And so there's a level of seriousness to the statement before it can be considered perjury. But perjury ought to be a violation of the code. It's bizarre that it's not. It may have just been so obvious, it may have been assumed.
Well, my reaction to that is, and there are any number of acts of misconduct punishable by law that or recognized as being acts of misconduct that are not in the code, but are inherently represent misconduct on the part of a village employee as that is broadly defined. And now what I'm looking through for the code is whether there is a general.
Yes, there is in 21.4R, as I recall, says that the list of bad acts above is not exclusive. But that's kind of a crappy position to be in, frankly, as a Board of Ethics member. You don't want to, first of all, you don't want to find people guilty. It's just an awful thing to do. And to sort of make up something that's not on the list isn't so great either. It's not a great place to be. And it's not as if the ethics board should be issuing, we could start having them issue regulations, which they're allowed to under the code. So I'm just saying a specific violation that should be in the list of 21.4, A through whatever letter through Q, should be added: a violation of your oath of office or violation of, I'll say, testimony under oath before any board. The perjury should be a violation. It should be specific. I mean, I can tell you there were at least 2 cases where there was no doubt in anyone who sat in the room's mind that somebody was not telling the truth and they were under oath, but we did not feel comfortable, given the politicalization of the environment by that point, of dealing with it. And we weren't going to start making up a code section under R at that point in time. Hard for me to imagine that perjury shouldn't be a violation of the code.
Mr. Chairman, I agree, but I wouldn't limit it to perjury. And I think that could be any act, you know, consistent with their official duties might be a violation of state or federal law. Should be the violation. I wouldn't narrow it.
But those aren't ethical violations. Those are state law violations.
Right. That this code is not.
It might be, but in my mind, if it's a state law violation, it should be a violation of this, right? If they're taking some act.
Yeah, I mean, I think if you want to say, we all know the state code is broader and less, maybe less all, even though broader, less encompassing in some strange way. But if you want to add a provision that said, you know, violations of state law shall be deemed a violation of the code, I guess you could do that. It's not a very good place for the Board of Ethics to do. We're barely equipped to do what we do day to day. I can only make the narrow point. It should be a violation to lie under oath, in your oath of office or in testimony.
Or you're taking some action inconsistent with your official duties, which might not be those 2 charges. So my feeling, and I've been pretty consistent through this, I'd like to establish, you know, a code here that leaves little to the imagination, that it's very definitive. If this happens, this is a violation.
Agreed.
So I think the best way to do it is to, you know, broaden the parameters to what is unacceptable conduct. And in my mind, any violation of the penal law or the federal law as it pertains to their official actions should be a violation of the ethics code.
I actually totally agree with that. I just was making a narrower comment consistent with what I was being asked to do. So I
Ellen,
think exactly right, Mike, 100% right.
Was that Ellen or Jocelyn who had a comment?
No, I was just going to say it was Ellen. To me, there's a difference, and I may be completely wrong, between a legal infraction versus an ethics code infraction. An ethics code violation is not necessarily against the law. And
True.
I think what's against the law is overriding everything. Because if we're going to start bringing in all illegal actions, this document's going to just go on and on and on and on and on.
The other practical problem, guys, having just done, you know, been doing this, is you only have a certain amount of resources. And that's why if it's we've had one case that I can think of in the last 5 years where something was brought to us. In the example I'm giving, it was actually a sworn complaint where we looked at it and said, this requires a professional, investigative, criminal, you know, experienced body. This is not for us. And I think it's, you know, I think it would be fair, Mike, to say if someone was found guilty of there's nothing wrong with saying a violation of federal or state laws deemed a violation of the ethics code. That seems easy. I'm just, again, back to my little comment, which is a suggestion you add a phrase, you know, a new R or a new S or whatever it is, the 21(4)C, that makes lying under oath to, violating your oath of office of the Village of Mamaroneck and violating, and by perjuring or lying to the ethics board or lying to any board under oath should be an ethics violation. it may be a criminal violation and it could be referred to them. But this board is not outfitted to determine criminal violations. Just don't have the capacity. If it's deemed, Mike, it's one thing. I don't, Mike, you're a lawyer too, I think, is if it's deemed, it's one thing. That's easy. But I don't think you want to have us try to become experts in criminal investigations, criminal law, etc.
Well, I'm going to take a page out of Ellen's book and suggest that we look at the model codes to see how and whether they address this question.
I don't remember that anywhere, Dan.
But can I just ask a question just because I'm into this now? Are you guys disagreeing that a violation of the oath of office or giving false testimony under oath should not be a violation of the code?
No, I think what we're saying, Mark, is whether it is so inherently a violation of certainly a violation of law, whether there is a remedy that either exists in the other sections of the village law, or whether the state law that prohibits or punishes false testimony is sufficient to deal with it, and whether we put this in the code to the exclusion of other kinds of acts of misconduct that might belong there too. And my comment is, as we have in other situations, is let's see how the model code of ethics models, the various models, whether they address this or whether false testimony can be brought in under another code provision as punishable.
With all
no, we're not.
I think you're confusing two things that are.
I don't think we're saying, no, we disagree with you.
I know, but Dan, I think you're, and I'll beg off, is 21.4 delineates whatever number is A through Q of specific things that are violations, misuse of authority, misuse of privilege, etc., gifts, all that junk, right? It's very specific. That doesn't mean other things are not covered or just because you didn't get a full list. What I'm saying is add one more. And the problem in your distinction or your discussion of a criminal versus this is an administrative proceeding subject to a standard of either arbitrary or capricious in the finding or substantial evidence. It is not the duty of the ethics board, and it would be crazy to then we're not giving criminal penalty level stuff. We're not giving the ability to take things away, take freedom away. If you import, it'd be one thing to say if they've been found in a court of jurisdiction to have violated state law, that's deemed to be. But to ask the ethics board to look at a potential criminal violation and then have to decide that whether that violation, which was designed for a standard of beyond a reasonable doubt, applies to an administrative hearing, I think you're mixing up concepts.
No, I disagree.
Okay.
I disagree completely. I think that somebody could, in fact, engage in conduct that could be a violation of either penal or the state penal code or the federal law that is not prosecuted, but that is very clear to a reasonable person following the standards of guilt that you're mentioning there.
I agree.
And that the Board of Ethics could, in fact, say, yes, we believe according to those standards that they violated that, and that and such would be a violation of the code. So I think we have to distinguish that not everything here, if it might be a violation of the criminal code, would be prosecuted.
Right. So you're saying basically, you're saying you could import the elements of a criminal violation without the standard of.
I'm following what you're saying, and I'm in agreement with you. I'm just establishing that not everything here that would be a violation of the law might get prosecuted, but it might be very apparent.
Of course.
And I think it would be something that the Board of Ethics should take action on. So I agree.
Of course.
Should add some catch-all language there to this document, but that limits it to the scope of their official action.
And I'll leave this with the comment. I wouldn't want perfect to be the enemy of good. And if you believe that you lie, if you lie under oath, I don't know what that has to do with, I mean, it might be a criminal violation. I don't know, but it ought to be a violation of the code. So that, I've said enough on that. Can I move on?
Yes.
Okay. This is a tricky one, and I'm not sure I have it all worked out, but everybody who's been involved, I know Nora would know this issue well, as anybody who was involved in all this would, is given that the ethics board is applying a code to consultants aside, John, officials and staff principally. That tends to be what happens. Principal and officials and staff, it is often the case it's just fine, as the code allows, to require the assistance of the village attorney. But there are occasionally, and it's only happened occasionally, where the village attorney was so imbued in the matter at hand, maybe even representing a board, maybe having given some advice. But I think there ought to be, and I don't, as I said, I don't think it's worked out, but there, you know, we've spent in 5 years essentially no money. There ought to be a way where there is a conflict that if, however one would determine that conflict, either the village attorney says I'm conflicted, or the Board of Ethics writes the Board of Trustees and says we have a conflict here, there ought to be some way to get assistance. And I don't think this is regular. I think this should be drafted by exception. But there are exceptional cases where I think someone other than the village attorney, and it could be somebody in the village attorney's office who is, they used to say, is Chinese walled off. But there have been cases where it was tricky to deal with, and it would have been more comfortable, I think, for everybody if there was another cost-efficient mechanism.
I don't think I quite understood that. Could you?
I think what Mark is asking about, the village attorney represents several land use boards, plus ostensibly when the ethics board is asking for advice, asking the village attorney for information. And you may have an issue where the land use boards have an issue that is being looked at by the ethics board, and as a result, you have an attorney giving advice to two boards at the same time.
Okay.
I agree,
John. That's helpful, but it's broad. It's a little broader than that. So let me.
No, but I mean, I understand. I think I understand your point, but I'm just trying to break it down a little.
Yeah, here give you an even. Let's just pick the mayor, just to pick someone because it's the highest officer in the village. The mayor is in constant, and this is not the example. It's just an easy one to use. Is in regular and daily talk, probably with the village attorney, right, or regular. And if there was a sense that there was a violation by the mayor, it would be a very, very awkward thing to say, village attorney, work on a case with us that we're investigating because we have a complaint against the mayor. And in your other job, just go and keep advising the mayor. That is an impossible position.
Yeah, I agree. And I think this, from my perspective, is easily resolved, that the committee should discuss allowing the BOE to have access to independent counsel on the rare occasion they need it. I think this is a ground ball. And I'm sure that the mayor is going to love to hear we're tossing his name around for ethics discussion here. So
I picked it because there's
from it.
So,
but I agree, Mark. I think that's very, very important for the board to have.
You could.
I don't know how the other committee feels. We can discuss it after.
You could require a certification by the Board of Ethics delivered to the BOT that says we believe there's a conflict, to make it serious and formal.
Sure.
But it has come up a couple of times as a problem. All right, those are my 4 special points. Do whatever you guys want.
Any questions, further questions to Mark, or comments regarding this?
It's interesting, Dan, you happen to be on an interesting spot, by the way. If you look at where your page is, my last comment, I never understood why we would ask somebody in this position to disclose they're all, first there's, I mean, someone could argue that there's issues with forcing someone to disclose political contributions, but I would at least narrow this down to contributions for whether it's village, state, county. But what relevance does it have that somebody wrote checks to 4 senators and 2 congressmen?
What are you referring to, please, Mark?
And just because it's at the bottom of the page you're on, I didn't want to lose that comment. So at the bottom of the page you're actually on in the right margin, I just didn't think political contributions, it's non sequitur to what we're talking about, but you happen to be there.
So you're saying in full, what is it that you're saying?
In section N, I just mentioned,
Yes.
We're gonna then go back to the top, but we're here right now. In the case of a 21(4)N disclosure, interest in legislation, official action, it differentiated than all other disclosures, requires the party to disclose all of their political contributions for the prior 12 months, I believe. Am I reading it fully correctly? And unless I missed something highly possible, all I'm saying is it should be limited to political contributions or call it local officials. So, I mean, why would you ask somebody who they gave money to for president as a result of making this disclosure?
Well, since it is entirely a matter of public record, there's no harm in calling for more disclosure.
Yeah, I just my point. That is reaching pretty far to ask people to say, I gave some money to somebody in California running for governor, and then have people, that seems like a tool to use for somebody going, oh, they're a Democrat, they're a Republican, they're a this, they're a that. So I'll leave it to you. It was a small point.
Okay. Any other questions, comments of Mark? If not, Mark, thank you for your appearing or visiting us or attending the meeting this evening, and for your contributions.
You'll see, thank you. You'll see throughout the document I put in comments which are easy to read and understand.
Okay, we will duly note them. Thank you.
Take care.
Thanks, Mark.
All right, thanks, Mark.
Okay. I know the hour is, we've been meeting for almost an hour and a half. Are there any other matters that anyone wishes to bring to our attention this evening?
Mr. Chair, could I ask one favor here? Just, after the last person appeared, I think it's important that if we just have some follow-up as a committee tonight, and I know it's getting late, just even 5 minutes, just to highlight those issues that we feel are important from Mr. Edinger's comments.
Okay.
While it's fresh in our minds. And, I would start, I have a couple things here. And I think one of the last things he said was the access to independent counsel. I would think that this would be something important that we would stress moving forward, that it allows the board to have access to counsel when they feel there might be conflict by using in-house counsel. Again, I don't want to spend more money, but I just think it prevents conflict.
Yeah, I mean, I understand the point, but I think I don't think there should be standing outside counsel for them. I mean, that's another expense on top of that. But certainly, if they make a request of the Board of Trustees for counsel, that should be acted upon.
I agree, John. I don't think it should be standing, but I think that they should know, and there should be a provision here that clearly establishes their right to ask the board for this, and the board should have it written here that they should be authorized to spend this money, and they should know that's available.
Right, but what I don't know about that, and I agree it probably is necessary, is how it would work. Procurement's not the right term for this, but through the village's procurement policies, approval for spending,
Yeah, the village.
Who can they go to, et cetera, et cetera?
Well, the village board of trustees is ultimately responsible for all of the boards, so they have to be the ones to approve any expenditure for any of the attorneys for any of the boards, like the land use boards or the ethics board. So, you know, I would imagine it would be no different than looking for special counsel for, you know, a zoning board issue.
And could I just add one more thing here? You know, I know we talked about this in the past. I don't think that we should worry about the money first, and I think we should provide the board with the best guidance possible, and then allow them to make the judgment based on the cost. On this, I think it's something that they could establish counsel once every 3 or 4 years, and it would be such a limited number of hours. It would be that important, but I don't want to get bogged in the cost, and I want to provide them what we think is the best product possible, and then they can make a determination if they think it's worthwhile.
Okay. Mike, anything further or any other further comments on what we discussed this evening? Okay. Are we okay for next Thursday at 6:30? Everybody okay for that?
Yes.
Good.
Yes.
All right. Let me just make one comment. I caught myself earlier calling out Mark's service at the Emmelyn, and I realized that I said so in the context of he's here for a reason, and Cindy Goldstein was there for a reason last week, and I just want to make a point in saying that as my comment on Mark was nothing more than a comment on Mark, I should also point out that Cindy Goldstein, Cindy and Steve were my down the street neighbors for probably 20 years. I think the world of Cindy and with her service to the village in so many roles. So I wanted to make that clear, that because I know this is kind of a hot button, that my my comment or praise of Mark's service to the Emmelyn had nothing to do other than noting that. So I want that in the record. And her kids, I think it was Zach, her son, was our babysitter for a long, long time. Okay, if there is, thank you all for the almost 2 hours of, hour and a half of time this evening. And with nothing further, is there a motion?
Before we do that, when we meet next week, can we go through the rest of Mark's edits or suggestions?
Well, I think what we can do, Ellen, is we'll take them in order.
Okay.
Next week we've got Tom Murphy. I assume if passes any prologue, it'll consume the hour. And then when we get back to the code, we'll pick up all of Mark's comments in order. I sent a memo to you guys which caught you up on the latest changes I made, and we were up to 21.7D, I think. So we'll start there once we get back to the sections, and we'll hit everything in order.
Okay.
Thank you, Dan.
So,
I had a question. Sorry. Can the video of the meeting be posted tomorrow somehow?
That's up to Nora, I think.
It's just difficult. Like the weekends are like the best to like check the minutes for me. Like having them Monday and then expecting them that Thursday is difficult.
So you're saying you have 5 minutes on the weekend, Brian?
I mean, I have all the weekend. I don't have 5 minutes during the week. Is what I'm trying to say.
Nora,
I like your haircut, Brian.
I can't get my camera's working. You know, it'll get emailed to Sally tomorrow, and she and Cliff will post it as soon as they can. But it may be that she can send Brian the link.
No, that'd be helpful. Thank you.
I mean, she said 2 weeks ago when we were emailing about it, she said she would do that. So I will check with Sally tomorrow.
Thank you. I appreciate it.
I think once I stop the recording, it gets emailed pretty quickly.
All right.
Okay, is there a motion to adjourn?
I make a motion to adjourn.
There's a second.
Second.
All in favor signify.
Aye.
Thank you all so very much, and we'll be in touch via the minutes and other comments in the agenda during the week. Good night to all.
All right, good night, thanks.
Thanks.
Bye.
Good night.
Night.
Night.